Hey, Patriot. Today, I want to take you into one of the most important Second Amendment battles currently unfolding in the United States. We're talking about Oregon's ballot measure 11-4, a sweeping statewide gun control law that has triggered a major constitutional showdown. Back in November 2022, voters in Oregon narrowly approved Measure 11-4, a law that requires a permit to purchase before buying any firearm and bans the sale, transfer, or possession of magazines holding more than 10 rounds. That slim margin, barely 50.7% to 49.3%, was the first sign that this issue would be anything but settled. Fast forward to now. A case called Arnold v. Kotek is challenging the measure, claiming it violates Article 1, Section 27 of the Oregon Constitution, which protects the right of individuals to bear arms. The case began in Harney County Circuit Court, moved to the Oregon Court of Appeals, and is now set for oral arguments before the Oregon Supreme Court on November 6th. In this video, I'll walk you through what this law actually does, how it ended up before the state's highest court, and what legal standards the justices will use to decide whether Oregon's gun restrictions can stand. So buckle up, because by the end of this episode, you'll understand not only why Measure 11-4 matters for Oregonians, but also how this case could ripple across the entire country. Let's start by demystifying what Oregon Ballot Measure 11-4 actually is, because despite all the headlines, very few people seem to know what it really does. Measure 11-4 was approved by Oregon voters on November 8, 2022, by one of the narrowest margins in the state's history, roughly 50.7% to 49.3%. On paper, it's called the Reduction of Gun Violence Act, and it contains two major components that immediately caught the attention of both gun rights advocates and gun control supporters. The first part is the permit to purchase system. Under this rule, anyone who wants to buy a firearm in Oregon must first obtain a permit from their local police chief or county sheriff. To qualify, an applicant needs to complete a state-approved firearm safety training course, undergo a fingerprint background check, and pay a small administrative fee. Essentially, it turns gun ownership into a process similar to getting a driver's license. You can't just walk into a store and buy a gun without prior clearance. The second part is the large-capacity magazine ban. This prohibits the sale, transfer, or possession of magazines that hold more than 10 rounds. Anything above that, say, a standard 15-round handgun mag or a 30-round rifle mag, is no longer legal to sell or even own, unless it was possessed before the law took effect. The stated purpose behind Measure 114 was to reduce mass shooting fatalities and ensure that anyone who purchases a gun has at least a basic understanding of firearm safety. But critics immediately argued that the measure overreached, violating not just the U.S. Second Amendment, but also Article 1, Section 27 of the Oregon Constitution, which protects the right to bear arms for the defense of themselves and the state. So from the very beginning, this wasn't just a public safety law, it was a constitutional time bomb waiting to go off. Enter the case that blew this issue wide open, Arnold v. Kotek. Almost immediately after Measure 114 passed, several Oregon residents, including Joseph Arnold and Cliff Asmussen, along with gun rights organizations, filed a lawsuit in Harney County Circuit Court. Their argument? That the measure violates the Oregon Constitution by restricting ordinary citizens from exercising their fundamental right to own and use firearms. Here's where things get interesting. In December 2022, Judge Robert S. Roscio of the Harney County Circuit Court agreed with them. He ruled that Measure 114 was unconstitutional and issued a permanent injunction, effectively blocking the law from being enforced anywhere in the state. For a brief moment, gun rights advocates celebrated, but that victory didn't last long. The state of Oregon immediately appealed the ruling to the Oregon Court of Appeals, which, after reviewing the arguments, issued a unanimous decision upholding Measure 114. The appellate court reasoned that the law was facially valid, meaning that even if it could cause constitutional issues in some situations, it was not unconstitutional in every possible application. Now the case has escalated to the Oregon Supreme Court, with oral arguments scheduled for November 6th. And this is where the legal framework gets fascinating. The Oregon Supreme Court doesn't just look at whether a law seems unfair, it applies a two-step test. Step 1. Does the regulation restrict something that falls under the protection of Article 1, Section 27, namely arms used for personal defense or the defense of the state? Step 2. If yes, the court then must balance the individual's constitutional rights against the public interest claimed by the state, in this case, preventing gun violence.
This is different from the U.S. Supreme Court's 2022 Bruin decision, which focuses solely on historical analogs. Oregon's standard allows for a bit more balancing, giving the state a slightly easier path to defend its regulations. Still, the plaintiffs argue that Measure 114 fails both steps. It restricts protected arms, since magazines are integral to a firearms operation, and the state's claimed safety benefits don't justify the infringement. In short, Arnold versus Kotek isn't just about one state's law. It's about how far a government can go in limiting gun ownership before crossing a constitutional line. Now that we've set the stage, let's look at what each side is actually arguing, because this case isn't just about bullets and paperwork. It's about how we interpret constitutional limits in the modern age. The state of Oregon, defending Measure 114, argues that this is not a ban on firearms at all. It's a reasonable regulation. In their view, the law doesn't prevent anyone from owning a gun. It simply adds safeguards to ensure guns are handled responsibly. Their central claim is that magazines holding more than 10 rounds aren't necessary for self-defense. The state cites data showing that in most defensive gun uses, fewer than 3 rounds are fired. Therefore, restricting large-capacity magazines supposedly reduces the potential for mass shootings, while having minimal impact on lawful self-defense. They also point out that similar bans already exist in other states, like California, Washington, and New York, and have been upheld by courts applying comparable constitutional standards. Oregon's position is that Measure 114 fits squarely within this trend of public safety-oriented firearm regulation. Finally, the state argues that the permit-to-purchase system actually strengthens the Second Amendment by promoting responsible ownership. It ensures that people who possess deadly weapons have at least some training and background verification, much like requiring driver's licenses for cars. The plaintiffs, on the other hand, see Measure 114 as a blatant constitutional overreach. Their core position is simple. Magazines are part of the firearm itself, and banning them effectively bans a component of arms themselves. They rely heavily on historical context, arguing that in 1859, when the Oregon Constitution was ratified, there were no laws restricting magazine capacity or mandating government-issued permits to buy weapons. Therefore, under Oregon's own constitutional text and tradition, Measure 114 cannot stand.
They also attack the balancing test used by Oregon courts, saying that it allows judges to weigh away constitutional rights based on vague notions of public interest. Instead, they argue that rights are rights, not privileges to be balanced against social goals. And finally, they note that criminals, by definition, don't follow gun laws. So while law-abiding citizens will face new hurdles, bad actors won't care about permits or capacity limits. In short, the plaintiffs say Measure 114 fails both legally and practically. It violates constitutional protections and doesn't make anyone safer. So, where does that leave us? Well, the stakes here are enormous, not just for Oregon, but for the entire national conversation on gun rights. If the Oregon Supreme Court upholds Measure 114, it would mark one of the most significant state-level endorsements of gun regulation since the U.S. Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruin. It would signal that, at least under state constitutions, courts can still uphold certain firearm restrictions, even when federal jurisprudence grows more skeptical of them. But if the court strikes it down, the ripple effects will be felt far beyond Oregon's borders. Such a ruling could embolden challenges to similar magazine bans in California, Washington, and Illinois, where plaintiffs are already lining up appeals. And there's a real possibility that this issue could make its way to the U.S. Supreme Court, creating a direct clash between state interpretations of the right to bear arms and federal Second Amendment standards. There's also a practical question. Even if Measure 114 survives, how will it be enforced? Some county sheriffs have already said they won't prioritize enforcement, arguing that their resources are better spent elsewhere. That means we could see a patchwork of compliance, where the law exists on paper but not evenly applied across the state. Meanwhile, if it's struck down, Oregon lawmakers could attempt a revised version, perhaps limiting only future sales of high-capacity magazines or adjusting the permit system to make it less burdensome. In either outcome, Arnold v. Kotek is likely to become a defining precedent for how state constitutions interact with gun regulation. It's not just a fight about 10 rounds of ammunition. It's a fight about where the boundary between liberty and safety really lies.
Legal battles like Arnold v. Kotek don't happen in a vacuum. They reflect the values, fears, and tensions of the society that creates them. And in Oregon, those tensions are on full display. The state has one of the highest gun ownership rates in the Pacific Northwest, but it's also home to large urban centers like Portland and Eugene, where voters have consistently supported stricter gun laws. That political split is exactly why Measure 114 barely squeaked by at the ballot box. It's the story of two Oregons colliding, one that sees guns as part of their culture and identity, and another that sees regulation as essential to safety and progress. Then there's the issue of enforcement. Several county sheriffs, especially in rural Oregon, have already declared that they won't enforce Measure 114, calling it unconstitutional and a misuse of law enforcement resources. In effect, Oregon may soon find itself with a patchwork of compliance, where the same law is treated very differently depending on your zip code. Meanwhile, national advocacy groups are watching closely. Organizations like Everytown for Gun Safety and the Firearms Policy Coalition have both invested heavily in the narrative around this case. For one side, Measure 114 represents a model for future state-level reform. For the other, it's a warning, an example of how far states might go in restricting fundamental rights. This divide isn't new, of course. The United States has been arguing about guns for centuries. But what makes this case so fascinating is how state constitutions, not the federal one, are now becoming the front line of the gun debate. Oregon isn't just fighting over magazine sizes. It's testing whether local democracy can redefine what bearing arms means in 2025.
But let's clear up a common misunderstanding. Myth-busting time. You can't just appeal to the Supreme Court because you disagree with the decision. The U.S. Supreme Court only takes a tiny fraction of cases, usually those involving conflicts between different states or major constitutional questions. So while this case might make it there, it's far from guaranteed. At the end of the day, laws like Measure 114 force us to confront a difficult truth. Freedom and safety exist in constant tension. Too much of one, and the other suffers. The challenge, and the genius of constitutional law, is finding where that balance should be drawn. So as we wait for Oregon's justices to make their ruling, I'll leave you with this question. Should the state have the power to decide how many rounds you can load into your magazine? Or does that power belong to you? Let me know what you think in the comments below.
And if this breakdown helped you see the issue like a lawyer, don't forget to like, share, and subscribe. And as always, use your newfound legal knowledge for good, not for evil.